15 CF 627, a case entitled State of Wisconsin Plaintiff versus James A. Barker III defendant. If you state your appearances for the record, please.
Good afternoon. Haley Johnson appears on behalf of the state as the special prosecutor.
James Barker, appearing pro se, objecting to Haley Johnson appearing with academic jurisdiction.
All right. So we're here today to continue these motions that have been heard twice before, and we have a number of issues. The first is a housekeeping matter. I did prepare an order based upon the court's ruling where Mr. Barker had made a motion that this court recuse itself or disqualify itself from presiding in this case. The order simply reflects what the oral ruling was on the record, and it's not for discussion. It's just a filing, giving you each a copy for your records, all right? So moving on from there, we had a number of filings since last time, but we're sort of in the middle of a motion, if you will. Mr. Barker had filed a motion to dismiss, which we're still getting to, and we had talked last time about his claim of spoliation and dealt with a number of issues there. My recollection is that when we concluded last time, Mr. Barker had indicated he wanted to subpoena some witnesses to be heard on his motion for spoliation. He said he had provided an affidavit of indigency to the clerk's office but never got anything back. Subsequent to that hearing, I personally called the clerk's office and talked with them, and they informed me that yes, he had on December 28th filed only the order form for the indigency issue, but he only made a partial filing. He had not filed what's required, the first part of it, which is the affidavit. So I asked the clerk to call Mr. Barker to let him know that he had not completed the filing on the issue of his indigency. I assume that you did that, Mr. Barker?
You asked me to call them or them to call me?
No, to contact you about completing the proper filing. Did you complete the proper filing on the issue of your indigency?
Well, I assumed that everything is supposed to be done electronically. I don't call the clerk. From my understanding, that they was going to file the document. They sent me something in the mail, but it wasn't the affidavit or nothing like that. Everything could they could simply just upload it, whatever needs to be done.
Regardless of how it was done, did you complete the form and
No, I
send it
did not.
in?
No, I did not. From my understanding, that they was going to contact me. They did send me a letter, and they stated that I was supposed to wait till court today or something like that. So they emailed something they uploaded something to my case record, and then they also sent the same letter in the mail, and it was copies of subpoenas that wasn't filled in, and I guess they was going to be the issue, and in the letter said something in regards.
Did you complete subpoenas?
I had already completed the service subpoenas by the time that those had came.
All right, so you did subpoena people for today's hearing on the issue of spoliation that you wanted to make a part of this record?
Yes, but before we get off into that, it's something that's a conflict of interest. According to the courts, Haley Jo Johnson has already withdrew from this case 3 times. And according, I believe it was March 2nd, she withdrew along with Judge Faith Flancher due to a conflict of interest. And now Zeke, Zeke Wiedenfield, whoever the DA was last time, he took testimony from Brian Van Sock, and due to the fact that it's a conflict of interest, Haley Jo Johnson recused herself. Also, Robert Jamboyce and Faith Flancher, they all recused themselves allegedly due to a conflict of interest according to the court order, and now she's right back on my case. So I'm moving the courts for a dismissal.
So you filed a motion to disqualify Ms. Johnson, is that it?
Yes, I did.
Okay, and that was filed yesterday, and I haven't seen it until now. It didn't come to me electronically or otherwise. Ms. Johnson, have you seen that motion?
I have not, Your Honor.
Okay. You served a copy on the DA, Mr. Barker?
I filed it. I filed it in the case records. And I don't know if that's a proper procedure to give her anything due she's here on her own individual capacity, because she hasn't been given proper authority to be here today represent the state, but because the Department of Administration haven't given her proper authority to do so. So I really didn't want to make too much contact with her due to the fact, like I said, she had already withdrew 3 times, and then after I filed the federal suit, she recused herself along with Judge Faye Flancher. And in the court order, it states that Judge Faye Flancher and others, I got it right here, but it basically states that Judge Faye Flancher recused herself because of conflict of interest. So of course, if there's a conflict of interest with Judge Faye Flancher due to me filing the federal suit, it's obviously a conflict of interest for Haley Joe Johnson as well.
All right, we're going to stop here. Then don't talk anymore. I'm going to print out a hard copy for you, and hand it to you and let you read it, and then we'll pause until you've read it. Okay?
Matter of fact, I got it right here.
You have a hard copy?
Yes.
Okay, hand it to her. Multiple pages, the one I have on the file here.
I'm talking about the order from.
No, not the order. I want to her to see the motion we just filed. Filed yesterday.
Oh no, I don't. Yeah, I got a hard copy, but I will.
We'll print one out.
You can print one for her.
And then we'll stop talking while we let her read it, okay? Thank you. Let me know when you've read it. Okay. No, not talking, waiting.
I'm done reading, Your Honor.
Okay. Would you care to respond to his suggestion that you're not qualified or able to legally be here?
Yes, Your Honor. I know that in the past, Judge Flancher has addressed many of these arguments. The reason why Mr. Barker may think that I withdrew from the case is I was on maternity leave, and DA Wiedenfeld stepped in to handle this case. And I believe that it's likely the changes with DA Wiedenfeld, my name, and Special Prosecutor Robert Jambois is filling in for me. We're likely just to have a record on CCAP of who is currently handling the case. For e-filing, I believe it matters that you have a name assigned. As far as the...
Objection.
No, let her speak, please, don't interrupt her. You'll have a chance to respond.
As DA Wiedenfeld was assigned as a special prosecutor, I can appear, I work in his office, essentially any assistant district attorney can appear in his stead. The reason why he filled out new paperwork is because when this case initially started, he was not employed in our office. Daniel Macy was the DA. So that's why there is that change. As far as the federal lawsuit, I have contacted the State Bar, specifically Tim Pierce, and I asked him if there's a conflict of interest for me. And his explanation for why there's not a conflict of interest for me compared to Judge Flancher is that I am a partial party. I represent the state's interests, whereas Judge Flancher has a duty to be impartial to both sides. So I don't believe that there's any illegal appointment. This issue has been addressed numerous times with Mr. Barker in the past. Moreover, the federal suit does not, according to the State Bar ethics, a person does not present an issue. However, I rely on the discretion of the court.
All right, thank you. Talk to me, Dr. Hurd. You want to say something in response to what she said?
Yes, exactly, I do. I kind of assumed that it was going to go this way. But yes, Haley Joe Johnson, first of all, as I stated in the motion, if we go all the way back to the first appointment of special prosecutor, first of all, she didn't swear to the appointment of special prosecutor. She began representing the state in her own individual capacity on September 16th of 2016. She didn't swear to the appointment of special prosecutor until November 29th. So she had represented the state in her individual capacity 2 times before she even submitted an affidavit to the Department of Administration and waited on their approval. It's mandated that you have to first get the Department of Administration's approval before you can become a special prosecutor. So she was fraudulently applying in court here representing the state on September 16th of 2016 and October 21st of 2016. After I went and requested a copy of the appointment of special prosecution form affidavit on November 29th, she then finally swore to the oath. And even on the oath, she failed to state the reason for her prosecutor assignment. And as I stated, she didn't swear to it in timely. So therefore, she's acting as a counsel for the state in her individual capacity. And yes, she did go on paternity leave, but she also came back, reassigned herself as prosecutor, and then when I filed the federal suit, she recused herself, she withdrew again, and then some guy named Robert Jambois became the prosecutor for literally like an hour, and then he recused himself, withdrew, and then she reappointed herself, and then withdrew again. Then Sam, what's his name, Zeke Weinford, whatever, he was appointed, and then after Brian Van Sock took the stand at the last court date and testified contrary to what Zeke had stated, I believe those are the reasons why he withdrew from the case, because Brian Van Sock's testimony kind of made him look bad because he kind of got to understand and committed perjury after Zeke had stated for the record that Van Sock told him that he didn't have the interview with Josh Golden.
Now you're getting off point here. We're talking about whether this prosecutor should be disqualified or not. You're wandering all over the place again.
Well,
you have a tendency to do. with respect to whether or not Ms. Johnson is legally able to be here and to proceed as special prosecutor in this case. Number one, she is an assistant district attorney in the Walworth County District Attorney's Office, where Mr. Zeke Wiedenfeld is the properly and duly appointed and elected district attorney. He was here the last two hearings that we had before this court, and he clearly stated on the record that the reason he was appearing and that Ms. Johnson from his office would be appearing in the future because she was on maternity leave, so that she was not able to be here. There is, in fact, a valid order appointing Zeke Wiedenfeld as the special prosecutor on file, which I've looked at in the past.
And it says
Then don't argue with me and don't interrupt me again, please.
Objection.
Stop interrupting. I'm speaking now. So that the order is on file. He is properly appointed as the special prosecutor in this case at the request of DA Patricia Hanson and as approved by the Department of Administration. He has, in my opinion, legally the right to designate an assistant in his office in his stead to proceed in this matter as the prosecutor, and I think he's done that. There are also documents in the past apparently where Ms. Johnson's name is added to the record, but I'm satisfied that she is validly and legally here as a special prosecutor, and there's no basis in law or in fact to disqualify her from proceeding in this matter. I commend her for what she's done. My view as a judge has always been that lawyers are the guardians of their own performance and their own compliance with the code of ethics. And she's done what lawyers are recommended to do. She, recognizing this issue, contacted the office that regulates lawyer conduct and got an opinion from them that because of her role here as a prosecutor, not as a judge, that she is not in any way in a conflict situation in light of the fact that you may have named her in some pending federal litigation. So that being said, I'm satisfied she does have authority to remain here and to act as a special prosecutor in this case. All right? So we'll go on from here.
I want to add one more thing. Objection. The affidavit for appointment of special prosecutor sworn to by Zeke says he was appointed for a conflict of interest. So even that says conflict of interest. And the other order says conflict of interest. And here she's back for the third time. But of course I'm not going to get into justice, but I object to, for the record, I object to everything you say. She don't even have, can she bring forth the record? Do she have a record? Do she have anything in writing from the Department of Administration saying that?
Okay, we're beyond that point now. You're continuing to argue the same points. We'll move on to the next issue, all right? So do you have witnesses here that you want to call to testify on the issue of spoliation?
Yes, but the biggest issue is this first. You stated that you were going to contact the clerk of court office about the issue. I told you I filed on March 24, 2017, I believe, the disc that shows investigator Chad Schulman in my driveway executing an unsigned search warrant. And you stated that you were going to contact the clerk of court office and see if they still had the DVD, and then you were going to contact me and let me know if they had the DVD or not. I've been trying to present this evidence of my Fourth Amendment rights being violated. I got it on video, and I would like to present it to the courts. And I haven't. At the last court date, I gave Zeke I can't think of his last name, but the last prosecutor, Wiedenfield, I gave him a copy of the disc, and I also gave him a copy of all the unsigned search warrants with the wrong issue dates and affidavits. And did he forward them to you? Did he give you those unsigned search warrants with the wrong issue dates, the unsigned and unsworn affidavits that I was given to by Attorney David Sedala that came from it? Did he give you those?
He gave me the entire file that he had. I haven't looked at each specific item.
Did you look at the Racine County Sheriff Department executing unsigned search warrant in my driveway?
The link you sent?
Yes.
No, because I would have to access Facebook and I can't do that from my work computer.
Okay, well, did he give you the DVD disc that I gave him? I gave him a DVD disc for him to view because it's, you are to uphold the law.
Are you needing it to be played?
Yes, I want to show you exculpatory evidence. a search warrant had to be signed by a judge, and I got video of them executing an unsigned search warrant at my property. And so therefore, all evidence should be suppressed because of that reason. The search warrant is signed by your key witness, who also have committed perjury a few times already.
And Your Honor, perhaps you can just clarify that Mr. Barker isn't here today to present to me, he's to present to the court.
Right.
Yeah. Well, present to the court, yeah. But it seemed like yeah. So
we're going to stop here on this issue for a moment and deal with a request, a motion that's been filed by Judge Nielsen, formerly Mr. Barker's attorney, representing him in this matter, to quash a subpoena that you had served on him.
Yes. I mean, this is all new stuff. That's really prejudiced me because it's taken into what I came to court to do. I came to court to present my video evidence. This court is supposed to protect my constitutional rights, and that's not. I'm telling you on record that I have video of my constitutional rights being violated. Can I present the court the video with my constitutional rights being violated?
As a courtesy to Mr. Nielsen, we're going to deal with his motion to quash your subpoena to him.
What about the courtesy to me? Objection.
Okay.
I've been coming to court for 3 years.
We'll get to that. And yes, and I've been here 4 times now, and we don't seem to get anywhere because you keep backtracking and going around in circles, dealing with issues that have been discussed and discussed and discussed.
Objection.
Right? So let's ask Mr. Nielsen to make a statement if he wishes regarding the subpoena that he's received.
Thank you, Your Honor. My name is Mark Nielsen. I'm a proposed witness in this matter. Although I have not yet received the subpoena, I'm aware that it's out, and I move to quash it. Well, first I ask that the defendant be required to justify it. He has filed a written statement justifying his subpoena. I now move to quash it because if I concede every point in his justification, I have no testimony to give which would bear on trial on the merits. Mr. Barker has a belief that there's something wrong with the legality of the search in his case, and that I have some sort of knowledge with regard to that. All well and good, but I've been subpoenaed for the trial, and that's not a trial issue. Therefore, the subpoena is not likely to elicit, and by the way, I would not testify to what Mr. Barker seems to think I would. Be that as it may, if I did testify as to what he thinks I would, I'd have nothing to offer at trial. Therefore, I ask that the subpoena be quashed.
Mr. Barker, you want to respond? What is maybe you can make a statement by way of an offer of proof. If Mr. Nielsen were called to testify, what evidence would you elicit from him that would be admissible at trial? I
have better evidence than something written or said. I have it in video. Mr. Nielsen testified, and that's the reason. Can I exercise my constitutional rights? I got everything in video and audio. What better evidence is video and audio?
What is the evidence?
I have Mr. Nielsen testified on August 3rd of 2016 that he spent the entire morning of December 7th going through all the original search warrants inside the felony case office. Me and my attorney, and I also had that audio and video recorded, my following attorney, Tony Young, we went to the felony case office on several occasions, also me and Yvonne McNeil, and they told us, I have it in audio recording from Tracy Workins-Kutch, Victoria Warden, Amy Vanderhoff, and Caitlin Presser, stating the search warrants don't exist. So therefore, the search warrants is an essential piece of my trial. He testified that he got them from the clerk of court office. The clerk of court office saying he's lying. The search warrants that he gave me isn't even valid search warrants. They're missing the notary seal. They're missing just to my breadth search warrant. I got the video of them executing the search warrant that was left at my house, which was unsigned and signed by investigator Brian Van Sack. I got that on video of them executing the unsigned search warrant. But while I was incarcerated, between Mark Nielsen and attorney David Sedana was the two attorneys that I had while I was incarcerated. They gave me, first, David Sedana gave me blank search warrants with the wrong issue dated June 23rd and blank affidavits with no notary seal, with totally blank jurat section, and then he later gave me signed search warrants, and then I fired him and hired Martin Wilson, and Martin Wilson came and gave me additional signed search warrants. To my house alone, there's 5 different search warrants to my residence alone. There was only one warrant executed at my residence on April 23rd, 2015. I have 5 different. One dated April 22nd, issue dated April 22nd, one issue dated April 23rd, one issue dated June 23rd, and another one issue dated June 23rd. And they're all, as a matter of fact, I got the warrants right here. So I have, and then the legal custodian of the search warrant records is clerk of courts. Clerk of court, I have them on video saying, we don't get police reports, we don't get search warrants, we don't get originals. And Tracy Workers could say verbatim, if they ain't here, either the DA didn't send it to us, or they don't exist. I have that in video recording. I have in writing for my, and in audio recording for my attorney, Tony Young, while we were at the felony case office, inside, behind the glass, requesting the warrants, and that's when she said, the search warrants don't exist. Therefore, either Mark Nielsen and David Sedani gave me forged records, and at the time I didn't know about the cell phone video that existed of them executing the unsigned search warrant, and so that is the reason why I'm trying to bring forth the video evidence. I know everybody tired of being drugged in and out of court, just like me. I've been fighting. I sat in jail 10 months for these charges. They have admitted they don't have any evidence to prosecute me. My co-defendants, they have nothing to prosecute me, and I keep getting drugged into court. And it could be end all if you just let me play the video in court.
Well, in terms of Mr. Nielsen's motion, Mr. Nielsen, any response you want to make to that as to how your testimony would be relevant on those issues? Or would be, I guess, presentable or admissible?
Okay, the one thing I've always noted about Mr. Barker is that he's focused on whether the evidence obtained against him by the sheriff's department was obtained legally. He's never disputed the evidence itself. At a motion to suppress, the issue of the validity of the warrants would certainly, or might be relevant. But at trial, which is what I'm subpoenaed for,
Right.
The warrants have no bearing.
Objection. The warrants have merit. The warrants are upon affidavit. Information inside the affidavit is what the case is based on.
Yes,
So
well, let me deal with it this way. To explain to you, legal issues are issues for the court to decide. The jury only decides issues of fact. So when we get to the trial before the jury, the state, which has the burden of proof, will present the facts that they believe support the elements of the offenses with which you're charged. They will not, they may mention the search warrant, but the validity of the search warrant and all that information has nothing to do with the jury. It's a legal issue to be decided by the court. I believe some of it's already been decided by Judge Flancher, and some of it was dealt with last time by this court. But search warrants are, again, challenged based on legal issues. Legal issues are issues to be heard by the court and not issues decided by a jury. So you won't be presenting information about the legality of the search warrants to the jury, okay?